So if the court is going to interpret the statute based on what it says, rather than based on the purposes or perhaps the overarching goals of what the 1934 legislature might have been, there's no way it could accept the government's construction of the statute because it is changing the enacted words.
Can I give you a way, possibly?
Please.
All right, so the statute says function, as we've all identified.
Yes.
And as far as I can tell, the sort of common usage of the word function is not its operational design. It's not the mechanics of the thing. It is what it achieves, what it's being used for. So I found definitions. Function is defined as the action for which a person or thing is specifically fitted or used, the acts or operations expected of the person or thing. So if you take that definition, it seems to me that through its use of the word function, Congress was trying to capture a class of weapons in which a trigger is used once to achieve a certain result, which says in the statute automatic firing many times. And so weapons with bump stocks have triggers that function in the same way. Through a single, pull of the trigger or touch of the trigger, you achieve the same result of automatic fire of the weapon. So why is that inconsistent with grammar or the way the statute reads?
Well, the premise of Your Honor's question is not true. A single discharge of the trigger produces only one shot. It doesn't produce a round of automatic fire. The only way you get to repeated shots with a bump stock equipped rifle is for the shooter himself to continually undertake manual action by thrusting the forestock of the rifle forward with his non-shooting hand.
But that's not the trigger. He's only he's holding the trigger or touched the trigger once, right?
No, he touches the trigger every single time. He has to bump the trigger.
I'm sorry, the machine is moving
the machine,
to make
the machine is moving, but
okay.
the trigger has to be
bumped. So let me ask you a question.
Yes.
The other question is, I understood this to be a classification statute in the sense that Congress is trying to identify and classify certain weapons. So if you're right, I want to understand why that matters. Why does it matter for the purpose of this statute that we have backwards pressure in the ordinary case of a machine gun and forward pressure here? You're saying there's a distinction being drawn. Bump stocks don't fit into this category because of this distinction, and I guess I don't understand why Congress would have prohibited one and not the other. Why does it matter?
Well, it matters because the statute turns on whether the bump stock equipped rifle will fire more than one shot automatically by a single function of the trigger.
The statute is in context. The statute is classifying certain weapons for prohibition.
Right.
So for it to make sense, we have to understand why this category of weapons are ones that Congress wants to prohibit. And you're suggesting that Congress is prohibiting through this classification weapons in which we hold it backwards and automatic fire happens, but we push it forward and automatic fire happens. Congress says no.
There's no automatic fire. I'm sorry, Justice Jackson. There is no automatic fire.
Sorry, 800 bullet. The conversation with Justice Kagan suggested that through a bump stock you can achieve the same kinds of result in terms of the amounts of bullets that are being ejected.
That is
true.
Correct? It has a very high rate of fire, but it's not automatic.
Right, but what I'm suggesting is that the category of prohibition is about the high rate of fire as opposed to, the movement of the trigger. And if you're right that it's about the movement of the trigger, I'm just asking why. Why would Congress want to prohibit certain things based on whether the trigger is moving as opposed to certain things that can achieve this lethal kind of spray of bullets?
Because the statute was written in 1934, about 100 years before we had bump stocks. So Congress drafted the statute at that time to capture the type of weaponry it wanted to prohibit in 1934.